Tonight, minority in parliament describes High Court judgment sentencing Ashanti regional chairman of the MPP to 20 years imprisonment as full of major defects after accusing government of selective justice in the Galamsey fight.
The refusal to refer serious constitutional questions to the Supreme Court. The trial judge decided for herself that Section 99 2B of the Minerals and Mining Act was, in her own words, clear and unambiguous.
Plus, we'll tell you the final words of the Ashanti regional chairman of the MPP before he was thrown into jail.
Hang on, work hard for the party, protect the party, bring Dr. Baumia to power, and I'll be fine. Those were his words.
We've got the latest of these and many more coming up shortly. Top story is brought to you by Telecel Connecting Energies. Holy insecticide spray and coil. Enjoy a holy sleep. Shield Pension Trust into the future with you. My name is Kenneth. Gyasi, when we return from the break, we speak to Wontumi's lawyer, the NDC and the MPP. Don't go anywhere.
Yo, Charlie, Telecel Fixed Broadband upgrade. Oh, you get up to 40% more data on the same old bundles. Best part, the bundles don't expire.
That's how we like it in the town.
Yeah, from on-cap speeds to fixed line calls and flexible data moves that allows you to move data up to 4 devices. Telecel offers an unmatched band for fixed broadband solutions for every need.
Telecel Fixed Broadband has got you.
For your home or business, experience the true broadband difference with up to 40% more data on Telecel Fixed Broadband at the same price. Move your non-expiry data to up to 4 devices. Get free fixed line calls and more tailored fixed broadband solutions for your home or business. Subscribe at www.telecel.com or download the Telecel Play app or visit a Telecel retail shop today.
Telecel, connecting energies.
Moolah Sports. See the all sharp, no long thing. MoolahSports.com.gh. Instant win, instant cash out. MoolahSports.com.gh. Moolah Sports, we the run the city. Play, win, cash out. Yes, play and stand the chance to win Moolah at MoolahSports.com.gh. Enjoy premium soccer action, exciting trips on the aviator plane, and exciting spins on all your favorite virtual games. Moolah Sports. More Moolah. Bet responsibly. Gambling can be addictive. Not for persons under 18. This advertisement is regulated by the Gaming Commission of Ghana.
Missed passes, bad referee decisions.
Don't let your child's grade suffer a bad match. Ensure a straight win this academic season with curriculum-aligned textbooks and interactive tools from Pegasus Publishing.
From preschool to senior high school, we have the exact game plan your kids need to ace their classes. And because it's World Cup season, you get a massive 20% off every single book. Don't drop points. Call 059-50-10-10175 or dash to Pegasus Publishing in Accra, Newtown, right opposite the Total Energy Station. Free delivery within Accra when you call. Pegasus Publishing, shaping minds, winning futures.
Palladium Residences in Achimota isn't just an address, it's the home you've truly earned. Secure your place with just a 10% deposit and choose from beautifully designed modern apartments or spacious townhouses built for everyday comfort. This is more than a building. It's a vibrant curated community with a clubhouse, state-of-the-art gym and an on-site hotel, all at ABC Junction, minutes from Achimota Mall. Enjoy city energy whilst retreating to your private sanctuary. Call now to reserve your unit and benefit from limited launch incentives, including priority unit selection. Don't miss the chance to pick the best homes. Book your private site visit today. Call 050-9823-424. Palladium Residences. Live smart, invest better.
Son, we are so proud of you for setting up this hospital. I really love those hospital beds and waiting chairs. By the way, did you import them?
No, Dad, I didn't. I actually got them from Kindle Books and Stationery right here in Ghana.
Wow. We also bought our office supplies, safes, executive desks and chairs from Kingdom, and they gave us expert advice on how to set up our office.
Guys, that makes 3 of us. I also got our sofa and bedroom sets, plus our dining hall furniture for our new home from Kingdom.
Wow, Mom, that makes 4 of us. I usually get my stationery items from Kingdom Kingdom, and my teacher also mentioned that our classroom furniture was provided by Kingdom.
So there you have it. Whenever you're thinking about setting up an office or acquiring furniture for your home, etc., Kingdom Books and Stationery should be your first port of call. With over 40 years experience in the industry, we stock and supply a wide variety of globally sourced office and home furniture, stationery and equipment. Visit our head office, Takweje, Osu near the Osu Cemetery, Tema near Community 4, Takoradi opposite Vijay Mays Plaza, Cape Coast University Bookshop, Spintex Road near Absa Bank, Atomic Center Point Mall, Winneba University Campus, KNUST, the University Bookshop, and Santasi in Kumasi. You can also visit our shop online, www.kingdomstoreonline.com. Hurry while stock lasts. For further inquiries, contact us on 050-162-0810 or 0302-764-101. Email info@kingdomgh.com. Kingdom Books and Stationery Limited, where quality and affordability is assured. Terms and conditions apply.
Hello again. Let's begin from Parliament, where the minority in the House says the decision of the High Court regarding the sentencing of the MPP's Ashanti Regional Chairman Bernard Antwi-Boasiako, also known as Chairman Wontumi, to 20 years in jail, is full of major defects. According to the caucus, the refusal of the judge to refer the issue to the Supreme Court has occasioned a substantial miscarriage of justice. Speaking to journalists in Parliament, Deputy Minority Leader Patricia Appiah said the minority caucus will embark on a lawful path to ensure Chairman Wontumi gets justice.
The minority would do whatever is lawfully and properly within its power through Parliament and through public advocacy to see that justice is done and that the defects which have robbed the judgment of its legitimacy are corrected. 4 serious defects run through this case, and each deserves nation's full attention. First, the denial of a counsel of choice. We understand that judgment was delivered despite the absence of Chairman Wontumi's lead counsel, whose office had notified the court of a prior professional engagement abroad. Second, the refusal to refer serious constitutional questions to the Supreme Court. The trial judge decided for herself that Section 99 2B of the Minerals and Mining Act was, in her own words, clear and unambiguous. Third, and perhaps most vulnerable of all on the law, is how the court pierced Akunta Mining Limited's corporate veil to convict Chairman Wontumi personally. The judgment convicted Wontumi and the company separately on separate counts, using reasoning that treats them as one and the same. A court cannot dissolve a company to convict the man.
Patricia Appiah is the Deputy Minority Leader in Parliament. Let's still stay in the House and speak to our resident correspondent, Kweku Ashanti. He was there for us and is joining me for more on this. Kweku, why are they accusing the Attorney General of selective justice, the minority? Hello, Kweku, do I have you? Right, we're still trying to work the lines to connect with Kweku Ashanti there, but we can listen to the minority again as they accuse the Attorney General of selective justice.
In July of last year, the Attorney General directed an investigation into the NDC's own national organizer, Mr. Joseph Yami, and its vice chairman, Mr. Yakubu Abanga, over allegations of illegal mining. Months later, there is no comparable update on charges or trial dates. The government member of Parliament has publicly acknowledged overseeing a mining site taken over from its lawful owners with no prosecution to date. And an NDC member of Parliament charged over an anti-Galamsey clash was granted bail within days. This pattern, taken together, sustains a reasonable perception that the machinery of the state moves fastest and land hardest when it is pointed at the political opposition. A government serious about ending selective justice must prosecute its own with the same vigor it has shown here.
That there is Patricia Appiah. She's the Deputy Minority Leader. Kweku Asante is our resident correspondent in Parliament. He was there for us and is joining me for more on this. Kweku, we've heard the accusation of the minority against the Attorney General of selective justice, and they are also making several demands. What are some of those?
Well, Ken, according to the minority, they expect the Attorney General to publish the specifics of the enforcement actions that are being taken as it relates to illegal mining in Galamsey. Because as far as they are concerned, the government is paying lip service, going after persons like Chairman Wontumi, while leaving NDC officials and other public officials neck deep in the illegal mining fight. And so they expect the government to do that. They also want the judiciary to be firm in defending the rights of people like Chairman Wontumi. Listen to Patricia Appiah again making this point.
Kweku, we will bring that soundbite of Patricia Appiah a bit later. But apart from this, what else has been happening in Parliament today?
Well, the minority in Parliament indeed came today to Parliament wearing black to signal their anger and their opposition to the sentencing of Chairman Wontumi. And then you see a number of the MPs, including the leader himself, wearing black all over. A number of them, you approach them to try and speak to them. They'll tell you that this is a very, very, very dark moment for the party as far as this issue is concerned. Of course, the land minister was also in Parliament to answer questions about the illegal mining menace, what is happening to DCs and MMDCs who are charging for equipment to be used and all of that. So it's been a day shadowed partly by this conviction of Chairman Wontumi, with the minority making the opposition very known.
Kweku Asante there, thank you very much. We can now listen to the demands that were being made by the minority during the press conference earlier today.
We therefore call on the Attorney General to publish the state's enforcement record on illegal mining across the political spectrum. We call on the Court of Appeal to scrutinize the denial of counsel, the refusal to refer, and the veil piercing with equal and unflinching rigor. We call on the judiciary to reaffirm the threshold for constitutional referral, with express regard to the Supreme Court's own decision in the Zanato case. And we call on all Ghanaians of every party to insist that the standard which cleared Mr. Chikese's name in 2016 be demanded with equal conviction today. Let us be clear about what this statement is not. It is not an attack on the judiciary as an institution. It is a call for consistency, for constitutional fidelity, for a justice system that inspires confidence across the political divide and not merely within it.
Well, Chairman Wontumi spokesperson Dr. Palgrave Boachidanko has also revealed the final words the Ashanti Regional MPP chairman uttered before he was bundled into a vehicle and taken to the Nsawe medium security prison. Listen to him.
Chairman told me to hang on, work hard for the party, bring the party back to power, and get a governance ongoing. And so those were his last words to me. Hang on, work hard for the party, protect the party, bring Dr. Baumia to power, and I'll be fine. Those were his words.
I saw one of your videos in which you were very emotional. You took off your glasses, you bowed down your head. I saw a police officer standing on your right side. At that particular moment, what was going through your head?
A lot of things that I cannot even think about. I was basically thinking about Chairman Wontumi. I was Patriotic Party thinking about our flag bearer. We are very much aware that this is clear political victimization. Chairman Wontumi is an election bulldozer. He wins elections for the biggest opposition party that left governance a few months ago. And so, I mean, I was basically thinking about everything and praying for him. But I mean, it was a very difficult moment, as you have stated. I haven't been able to recover from it, and I'm not too sure that I can. Looking at the issues that are unraveling afterwards.
The Chairman Wontumi, we all know, is very animated anytime he appears in court. I mean, he says that he's the attention. Let's go back again to the courtroom, the moment that sentence was passed, and he noticed that he was going to serve 20 years imprisonment. Take us to the courtroom. What was his mood like?
He wasn't happy. Your court correspondents will tell you he wasn't happy. He kept shaking his head, no, 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 no. And so I could read those gestures. Clearly in disagreement with the convictions that her ladyship, Audrey, had placed out, and also in disagreement with the final sentencing. But I mean, he's a strong man. He's mentally strong. He's morally strong. He's emotionally strong. And I know that he will survive this journey.
Well, I saw him exit his car alone when he went to the court, and you also exited your car separately. So I take it to mean that both of you arrived at the court at separate times. But before getting to the court, you may have spoken before having your day in court yesterday. Was he confident that he was going to be exonerated, or he perhaps thought that anything could happen, including what happened yesterday?
Well, we were very confident that, as we have always walked into court and come out of court, we were confident that yesterday was going to be the same, because there were two motions that were raised by lawyer Appiah. One on some specific interpretation of the Constitution at the Supreme Court, and two on the stay of execution of judgment or pronouncement of judgment because the legal counsel is absent. I mean, of course, I've heard former Minister for Lands and Natural Resources, Senior Inusa Fuseni, claiming that, of course, judgment can be given without your lawyer, which is not a problem. But the fact that there are constitutional matters that needed interpretation, that the judge said she scratched those motions, it's something that should trouble all of us. And I'm sure that that would also trouble the learned community senior as well on the other side of the divide.
Appiah Dankwa is a special aide to Chairman Wontumi. Samuel Atachia is the lead counsel for Chairman Wontumi in the Samra Boy case. Is joining the conversation right now. Sanja Nanja is also a member of the Constitutional and Legal Affairs Committee in Parliament. He's also joining the conversation. Gentlemen, grateful for your time this evening. Samuel, let me begin with you. You were not in court when judgment was delivered. There are already questions as to why you were absent on such a critical day.
It's very unfortunate because of the hard fact that if I should let you know how personal it was for me to join my daughter who was graduating in the UK. I didn't see how I could absent myself. But for good measure, there was a constitutional matter staring at the court in the face. And we wanted to move that motion, which I knew if the judge will respect the hierarchy of the court and even the law, that referral should have been made, which would mean that I needn't be around, when a judgment is being pronounced. So these were the facts. I had not left Ghana to sort of leave my client in that kind of predicament. So that is the first point. I left Ghana on good measure that indeed and in fact my daughter was graduating and I needed to be around. That's all the matter is.
Okay, thanks for the clarification. Now, the minority MPP says the judgment is, quote, full of major defects. Specifically, do you agree with them, and which errors of law procedure will you be challenging in your appeal?
Well, so far we've assembled no less than 20 grounds of appeal. The first one is the constitutional imperative that her ladyship was bound to make a referral to Supreme Court for the determination of critical issues, in terms of Article 130 and then Article 1911, then Section 14.1, 59, 99, 2B, and Section 3 of the Minerals and Mining Act, as amended by Act 995. Let me make it very clear. Even the very authority that she cited in the judgment is that where rival meanings are placed on the Constitution by the parties. Rival meanings. So we said the manner of the charges and the way it's been couched, sins against Article 1911, and therefore the Supreme Court should interpret it. The 10 judges said no. That is to say, the Akunsa case that her ladyship cited has brought to the fore rival meanings. And then the judge graduated herself into the Supreme Court to make a determination of constitutional matters. For me, that is a very fundamental error which can quash the entire decision. Because the power to interpret the Constitution is not vested in the High Court judge. It's with the Supreme Court. And guess what she was saying? That, look, this is a statutory construction which is at stake. It was nowhere near statutory construction. It was a constitutional interpretation as to whether or not where they formulated a so-called criminal offense and the penal consequences are not clear. While the Constitution is saying that you cannot commit somebody for an offense unless the crime is well defined and the penalty thereof is also clearly known under Article 1911. So this is what I believe is a very, very serious matter that the judge ignored. It seems to me that the judge was in an ambulance mood to convict the guy. I do not see how any High Court judge will ignore serious and consequential constitutional interpretation and go ahead with the matter. What I even heard was very bad, that she refused to permit my lawyer who was in my absence to move the motion. So that if you have a closed mind, then it leaves much to be desired, because sometimes you have a closed mind. But if you permit the voice of another person to wade into your pigeonhole thinking, it could help you come to a better conclusion and a better understanding of the matter. So that's the first point. The second point, which I find very, very sad and unfortunate, and I don't want to discuss our appeal in the media space, but it will come out anyway. Can you imagine that the two critical witnesses who spoke against Wontumi were themselves culprits? Are you aware that these people are arrested, taken to court, and they were bailed by the same judge? And then the Attorney General cleverly converted them into prosecution witnesses. Do you know what it means? This is the insurance for their freedom. Can you come and testify against, Wontumi? And actually, they came and testified. And the authorities are clear that where people are involved in a crime and they are converted to, prosecution witnesses, then a court of law should treat their testimony with extreme caution because of the underlying issue of unreliability about their testimony. And I think we'll have to look at this.
Okay.
Further, if you want me to go on, one more thing, which for me is a big surprise. The judge refused to consider all the exculpatory evidence that were consistent with the innocence of Wontumi. Let me just give you one. Do you know Wontumi is the individual who wrote to RESEC, Western Region, that a lot of Galamsey groups have evaded the concession? So that evidence was not challenged. That he himself is anti-Galamsey crusader, how does he become a victim? If you look at the issue of assignment of mineral rights, the absurdity is too pronounced. I don't want to go into all that. How did he assign it? By what authority did he do that? Where is the documentation that it was by word of mouth? If it was by word of mouth, there is the oath of the culprits against Wontumi. And as to oath against who, authorities are clear. that everything which is a doubt inures to the benefit of the accused person. The judge went on with all these matters. By due season, we were exposed to the poverty of the judgment.
Right, don't go yet. I have Sanja Nanja also with me. He's a member of the Constitutional and Legal Affairs Committee in Parliament, also a member with the Majority Caucus in the House. Welcome to the program, Mr. Nanja. Well, the minority says Chairman Wontumi has been singled out while politically connected individuals continue to invade prosecution. How do you respond to the allegation of the selective justice that the minority says is happening right now? Hello, Mr. Nanja, do I have you? You would have to unmute your microphone so we can hear you. We're still working the lines to get Sanja Nanja to respond to some of the allegations against the government by the minority through their press conference earlier today. Samuel Appiah is still with me. He is the lead counsel for Chairman Wontumi there. Mr. Appiah, a 20-year custodial sentence is one of the harshest in an illegal mining case. Is your concern with the conviction itself, the length of the sentence, or all of them?
Both. My dear brother, there are principles governing the sentencing of a convicted individual. First of all, when the person is a first offender, there is the principle that leans favorably towards the individual. So if you said, okay, by operation of law, the minimum sentence is 15 years, and I'll settle with 15 years because this is the first time it's come against the forces of the law. People understand. I'd say that you want to make an example out of him. And I don't want to go political here, where we know an army of individuals who, with the greatest of respect, are doing Alamse and with cheeky ease. The government has not gone for them. That will lend credence to the fact that why is this guy the scapegoat in the realm? And why should he be visited with such a high sentence? So the sentence will also be part of the grounds of appeal that the sentence was harsh and unreasonable given the circumstances of the case.
Let's talk about the appeal. How soon are you going to start the appeal process? And also, your party, the MPP, says that they are going to take over the appeal process. Does that mean that you are going to recuse yourself from the appeal process, or you're going to have a collaboration with your party, the MPP? First, I want to pick your thought on when the appeal will be filed.
Well, very soon. You've just mentioned the collaborative effort, because there are good people in MPP who make up the legal committee. So we'll be cross-fertilizing, and then when it's due for us to file, we'll file it. But it will be something of very serious consequence. It's not going to be a very watery notice of appeal.
So how soon is very? This week, by the end of this week, next week, by the end of this month?
Well, I don't think it will exceed, next week. All factors being constant, it wouldn't exceed next week. We'll be able to formulate, serious grounds of appeal, which will be filed. And guess what is also a very serious dimension to this case? The self-same judge refused the application, the submission of no case made. If you remember that, there's what we call submission of no case at the end of the proceedings case, and that is also pending before the Court of Appeal. So therefore, if that is upheld, which we are going to really push hard, that means that the judgment is of no consequence.
Mr. Appiah, the Deputy Attorney General is insisting that this prosecution demonstrates that no one is above the law. So why do you believe your client has been treated differently from others accused of illegal mining?
In fairness to him, you understand, we have not said Wontumi is above the law. We won't say that for, the sense of our understanding of the rule of law. But we are saying that if you picked him out in the first instance against the backdrop of your own people doing galamsey, then it is suggestive of the fact that, oh, this is selective prosecution. You get the point? Because we know that even evidence has come to the fore that serious government officials are involved with galamsey. You could catalog it because you have a very primus of an individual, in Joy FM, who is an anti-galamsey crusader. So that is the point of the matter. In this case, it's very ugly in the sense that you want to believe people who are supposed to be charged with criminal offense and prosecuted. And then you are clever to say that, look, do you want to buy your freedom? Go and testify against this guy. Is that how you want to go along with such a situation? And anybody who has been arrested and then brought before a court of competent jurisdiction for doing galamsey and is admitted to bail will be very, very willing to, do this kind of job.
Right, Mr. Tachia, don't go yet. I'll come back to you. But in the meantime, Gemma is joining me in the studio with the Newsnight headlines. Gemma, what's coming up tonight?
So tonight, Office of the Special Prosecutor firmly rejects suggestions by a U.S. immigration court that its case against Kenneth contained no persuasive evidence of wrongdoing.
It is clearly legal absurdity for the Office of the Special Prosecutor to put forth such a statement. Is he trying to suggest that the decision was made in a vacuum without any material before the judge?
We'll get reactions from Ken Oforiatta's legal team and the OSP's justification. Also, Speaker of Parliament directs MPs to stop abusing sirens and police escorts as the Ghana Police Service mounts nationwide crackdown on the use of unauthorized sirens and horns.
The indiscriminate installation and use of sirens undermines road safety, weakens public confidence in lawful authority, and diminishes the effectiveness of emergency and security services.
Details as they intercept over 1,000 vehicles for using illegal modifications in Accra. National Service Personnel Association NASPA beats a retreat as it suspends controversial capacity building program following mounting pressure from service personnel on deductions made from their monthly allowance.
The capacity building program, as currently structured, is hereby suspended with immediate effect, pending a comprehensive review of the program for a decisive action to be taken, which is in line with our sector minister, the Minister of Youth, Empowerment and Development. There will be no further deductions on behalf of or in relation to the capacity building training.
We'll bring you details as the association says it will not refund deductions already made on the allowances. We also hear from the aggrieved service personnel in business.
Businesses describe first half of this year as good and encouraging as a result of improved macroeconomic situation.
In sports,
Ghana international Fatah Isahaku joins Premier League side Ipswich Town on a 5-year deal.
And on your say?
Well, for years, Ghanaians have known him as General Mosquito, but the NDC General Secretary says that's not the nickname he would like to be remembered by. We tell you why he answers to Archimedes. Well, as always, you can be part of our conversation. Share your thoughts on X with the hashtag Newsnight or send a text or voice note via WhatsApp on 055 11 11 997. 055 11 11 997. Do keep them brief.
And much later, Petroleum Commission's failure to sanction upstream oil companies for non-compliance leaves Ghana with $1.9 million in unpaid fines and 194 million Ghana cedis in lost revenue. That's according to the latest Auditor General's report.
I don't think it shows a commission that is really on top of its job.
We'll hear from ASAP, who says the commission should do better.
The enrollment was total.
In our Crumbling Start series, we tell you about an unpaid volunteer teacher, 6 months pregnant, yet still showing up every day at a basic school in the Savannah region and helping drive up enrollment.
The enrollment was totally down because sometimes you come 5 or 6 children. So when I started coming, we sing and we dance. So it was encouraging them to be coming.
These and many more later. But before that, Ken.
Indeed, and as I mentioned earlier, we still have Samuel Appiah. He's the lead counsel for Chairman Wontumi there. Mr. Appiah, you've already mentioned that you are going to collaborate with your party, the MPP, to file the appeal processes. If the Court of Appeal should uphold both the conviction and the sentence, are you prepared to take the matter to the Supreme Court?
Definitely. In fact, we will exercise our rights under the law. That when you lose in the High Court, you can appeal to the Court of Appeal. And when you are not, happy, with the decision of the Court of Appeal, the court of last resort is the Supreme Court. So we use all the arsenals that we have to ensure that we get justice.
You have already mentioned your reason for being absent on the day of judgment, but looking back at the conduct of the trial, do you think there is anything your defense team should have done differently, or you're convinced the outcome resulted solely from the errors by the court?
Well, you see, I wouldn't want to do a post-mortem of what the previous lawyer did and what I did. What I can tell you that when you look at the entire evidence as I inherited it, and the fact that I raised constitutional issues for the consideration of the judge, and he ignored it, and graduated the High Court into a Supreme Court, I can tell you that that's an aberration of justice, and we'll find our day in court.
There are those who also argue that you took this case during its twilight and that there's not much you could have done to defend Chairman Wontumi. Do you think this could have been one of the reasons why we witnessed the judgment that happened yesterday?
Well, I can tell you something which is very, very consequential, which is that I didn't start the whole case, and every lawyer has his own style. But looking at the poverty of the prosecution's case, and I will stress that, I've given you some hints. I do not see how this judgment is founded on law and evidence. Because for the world of me, I can't believe how those who are supposed to be charged, and then they get them to come and testify against the man who gave them the opportunity to go and do the reclamation on the land. Do you think they'll be able to tell the truth? Is it not an insurance for their liberty? So these are serious matters that we don't want to take for granted. Today we're talking about an assignment of a mining right on whose mere say so. And the man has not said, look, can you give me 250,000 United States dollars and I give you the concession? They didn't testify to that. They never said even they wanted the money from them. They said, go and do the reclamation. When you do the reclamation, try as much as possible to do coconut plantation on the reclaimed land. If the people were wayward, the two individuals who became the prosecution witnesses were wayward and they went on illegal mining, where is the mens rea in this matter? How do you want to attribute the criminal activities of the two individuals to Chairman Wontumi? These are serious matters. You're talking about circumstantial evidence as the pivot of your decision, because there was no direct evidence that there's a mineral rights transfer.
Mm-hmm.
And we have been educated that circumstantial evidence should lead irresistibly to one conclusion.
But many would argue that he allowed that to happen because the concession ultimately belongs to him.
Of course. So when you have a farm and you get hirelings to go and, harvest cassava or do something on the farm, you understand? Does it mean that you have assigned your ownership of the farm to them? The absurdity is monstrous. How can somebody say that if somebody is working on another man's concession, that is tantamount to assignment of mineral right? How does it happen? I don't get it. And meanwhile, the so-called prosecution witnesses never testify that the man has assigned the mineral rights to them. They never said so. So how can he be convicted? These are serious matters, and they are very consequential. So we won't give our eyes sleep until we see justice in the matter.
Samuel Atachia, don't go yet. I have Dr. Justice Shremsai. He's the Deputy Attorney General. He's joining the conversation this evening. Attorney General, welcome to the program. The minority in Parliament is alleging that this prosecution is an example of selective justice. And I want to find out from you what evidence you can point to show that the law is being applied equally, regardless of political affiliation in this particular case.
Hello, good evening. Please, can you hear me?
I can hear you loud and clear.
Yeah, I first of all need to correct some impressions that, my very good friend and senior has created. The first one was the last thing he said about assignment. It appears there is a misunderstanding of the charges that were brought against the accused persons from the perspective of my learned friend. And the charge did not say that there has been an assignment to anyone. If you read the particulars of offense, there's no mention of assignment there. The charge is simply that the accused person has allowed the PW1 to deal with the concession, without seeking the approval of the minister. There are a number of ways that you could, the law prohibits from, makes a crime if you handle a concession in that way. Assignment is one, mortgages is one, ordinary transfer is another. But beyond that, they said encumbrances. Encumbrances in law means that you have handled something in a manner which is inconsistent with the rights. And I think the judge did justice to that in explaining the particulars of offense. So there seems to be an obsession or fixation on assignment simply because the marginal note of the offense only reads assignment of mineral rights. But as every lawyer knows, the marginal note of a provision doesn't determine what the provision says when the body of the provision is clear. And it is clear that assignment is only one way of one prohibited way of dealing with a concession. There are other ways, prohibition, mortgages, transfers, and all. So I'm always surprised when this issue of assignment keeps coming up. In any case, the defense was based entirely on some understanding that the assignment must be in writing. But we know that even assuming that you are dealing with ordinary assignment of property, it is not always in writing. If assignment were only in writing, then all the assignment that have been done by our forefathers, our great-great-grandfathers on land and other resources would have been what? Invalid. In fact, the requirement of the law is that you should do so in writing, and the minister will give you the approval in writing. So if an accused person is telling you that he did not even put it into writing, that is the first breach of the law, because the law says do it in writing. So if you have done something in writing, if you have failed to do it in writing, is that not a breach of the law? These questions were put to the witnesses and accused persons themselves, that if the law says you should do it in writing, which all of us agree that it should be in writing, and you refuse to do it in writing, have you breached the law or not? If you check the record of proceedings, the witnesses were clear that they would rather answer and say that it means that you didn't assign it at all. That is what they keep saying. That so if we say don't drive without a license, okay, and you decide that you will drive without a license, and then you are caught, you say, show me that I have a license and I didn't use it. And that if you don't have the license. So if you look at it this way, there's some fundamental misunderstanding on the part of the defense counsel. And that is even obvious in this analysis that my learned friend told you this evening about assignment. Now, beside that, I am always interested in fair trial. Okay? Fair trial is what we all aspire to achieve, and we all must insist on fair trial. But when you raise an issue before a court that you believe that there is a question for interpretation, which ought to be referred to the Supreme Court, the authorities are clear that the fact that one party to a case claims that there is a constitutional issue does not mean that the judge should refer. I mean, since the days of McCann and Attorney General, through to Senator Rawlings, through to Gyasi Kwasin and all that, the position of the law has been clear that when a party alleges that there is a constitutional issue and which ought to be referred to the Supreme Court, the trial judge ought to examine whether indeed there is a real or a genuine issue. What really happened, and I understand my learned friend was not in court, so he probably is depending on what he has been told by persons who were in court. But what the judge said was clear that he doesn't see any real or genuine issue on the interpretation that they are asking. He doesn't see that there's any doubt on the meaning of the act. And what was their ground? Their ground was simply that the offense was created in a different section, and the punishment for the offense was also in a different section. And because of that, then there's a doubt, or there's a vagueness. But as far as I understand vagueness of law, it is not that the offense is in one section and the punishment is in another. That is a normal way of legislation. You create an offense in one section and say that anybody who commits this offense will be punished. So that is exactly the structure for the law and in Act 703. The offenses are created, and then there's a catch-all section which says that anybody who breaches any of the obligations in the law is to be punished by these sentences. If you think that is vagueness, and the court said, as far as they are concerned, it's not vagueness, what you can do is to appeal against that decision, but not to say that whenever you, a party, tells a court that there is a constitutional issue, then the court is bound to accept and refer the matter. That would have been absurd, because that would have been a very absurd position of the law, so that anybody who goes to court, and if there's a process you don't agree, and then you say that they should stay the proceedings and refer the matter to the Supreme Court, then the judge is bound to refer. And then there's a third argument, claim that my learned friend also made, that there were his lawyers that he sent to the court were not allowed to move the motion. Probably my senior was not in court, so he probably didn't understand what happened. His juniors that he sent, or his colleague lawyers that he sent, said that their instruction was to take a date, to take an adjournment. That was their instruction. And when a lawyer comes to you to say that my instruction is this, that is what he's saying is that this is the only thing I'm asked to do. And once the adjournment issue, the instruction to take adjournment was refused by the judge, and the judge gave detailed grounds for refusing the adjournment, because in the letter that was sent, the letter stated that because of prior engagements to the date, what this means is that counsel is telling the court that I have already had this arrangement before we agreed, before we took the dates, before the dates on which we have to be heard. So he will not be available. But you were the one who took the date. And that's what the court said. That it wasn't as if the court imposed the date on you.
Oh, Jesus.
You were in court and you agreed to the date. So there cannot be a prior arrangement which will conflict with this. And personally, I believe that, this whole rigmarole, as my learned senior would say, on this case and the judgment and all, it is creating a certain impression, especially when you add the fact that just yesterday, the lawyer who handed over to Lawyer Tachan said that he has been instructed to continue the case, even after conviction. What does that tell you? So is it that the right to counsel mean that at any point in time, you can just, go back and do back and forth? But that is beside the point. All I'm saying is that we need to, as lawyers, read the judgment. We need to reflect over the judgment, and then we can properly, as it were, inform ourselves as to the grounds of appeal. And I think it's early days for the attack that has been launched. As many as, how many grounds? 20 grounds of appeal?
Yeah, that's what he mentioned.
Interesting.
Well, Justice Shrimps, I want to come in here. Gemma, this is Gemma. So the minority, they say that Wontumi is a political prisoner. And the argument is that those who were indeed mining on his concession, we are talking about Henry Okum and the other one, Michael, they were the ones mining on the concession, and you managed to turn them into prosecution witnesses. They who were supposed to be the ones being punished or sanctioned for mining or engaging in illegal mining practices, you left them off the hook because you wanted the bigger fish, which is Wontumi. And so really, your agenda was to make sure that Wontumi is imprisoned and not to really punish the people involved in illegal mining. How do you react to that?
Thank you very much. I'm wondering what the point is. Is it the point that because someone else has committed a crime, then we should let another person who has equally committed a crime to go? Or we cannot punish one person unless we punish all the other people who have committed a crime?
Is the second one not an option as well?
Pardon?
Is the second one not an option as well?
It is an option, but you see, these two gentlemen that they are calling, that they are calling us, they took advantage of the plea bargaining law and entered a plea negotiation, which resulted in a non-prosecution agreement that we have entered with them. The accused person, that is Chairman Wontumi, he chose not to take advantage of the plea bargaining law and decided to go to trial. So
what's in for the state? Justice Shrimsai, so what's in for the state when Henry Okum and Michael decided to take the plea bargaining?
I think if you wait and listen to me more than you are asking questions, you understand what I'm trying to say. Please. What I'm saying is this. The two gentlemen entered into plea bargaining. And I believe you know what plea bargaining is, right? And when they entered to plea bargaining, a clause of the plea bargaining is for them to forfeit their excavators, the gold that was confiscated, and all other equipment. That is their consideration for the plea bargaining. So I think the public has been discussing this issue as if we just saw these two people and said, hey, come and testify for us and let's forgive you your sins. That was not what happened. They took advantage of the plea bargaining law. They bargained and forfeited their assets. A1 decided not to bargain. Pardon?
Please go ahead.
Yeah, A1, that is Wontumi, decided not to bargain to go to the trial. So, and if you see, that is why I say that we need to, as it were, read the judgment, because at the end of the judgment, the judge made orders of confiscation and all. So, and the judge stated in the judgment that we confiscated excavators, we confiscated gold, we confiscated other equipment. So, what did you think we did with those equipment? Those were the things that we used at the plea bargaining and entered a non-prosecution agreement as a result of the plea bargain for the two people, and as part of it, they were supposed to also be witnesses. And in any case, is it the case that unless you convict those guys, you cannot convict the Chairman Wontumi? Is that the argument?
You just mentioned that it was part of the judgment, the confiscation of the excavators and all the other equipment the police actually found at the mining concession when they raided the concession last year. So how come you now say that it was part of the plea bargaining? Was it before the court that these two individuals who were seen at the concession actually...
Are you in any way suggesting that you cannot forfeit your assets as a part of plea bargaining? and that when you do so, a judge cannot also confiscate other assets in the case.
So they were not the same assets you're talking about. So one for the plea bargaining and the one the judge ordered in the judgment yesterday.
I am telling you that you raise issues of how come the two gentlemen were used as prosecution witnesses, right? And I told you that these two gentlemen entered a plea negotiation which resulted in a non-prosecution agreement in respect of which they have forfeited their excavators and other equipment and gold and all, money and all that. And I also told you that even at the end of the trial, if you read the judge made confiscation orders. What I'm trying to tell you is that contrary to your initial opinion that there was some kind of unfair treatment of just allowing some criminals to go and convicting others, it is not that you are not creating the accurate picture. The accurate picture is that those people took advantage of plea bargaining, and as part of the plea bargaining, they are supposed to testify for the prosecution as well as forfeit their assets.
Right, Attorney General, point well noted. One other concern that a lot of people want to find out is the investigation of the national organizer of the NDC and also the third national vice chairman of the NDC as well. They were being investigated by Yoko for alleged involvement in Galamsey, and your office, the Attorney General Department, formally directed probe following complaints of the alleged involvement in Galamsey. We haven't publicly heard of the findings. Can you tell us what has come out of it?
Investigations are still ongoing. And let me add that it is not a valid point to suggest to compare these two matters. Chairman Wontumi's investigation started way back in 2021. We are in 2026.
Attorney General, we are not comparing. That is the accusation that was made by the minority in Parliament earlier today, and we are only finding out what the outcome of that investigation has been.
Can I finish making the point so that we don't miss what I'm saying? What I'm saying is that I've just told you, you asked me about the investigations, and you ask it suggesting that it is long overdue, right? Because I told you that the investigations are still ongoing. So if the suggestion is that it's long overdue, that must be some comparison you are making, because you would not say it is long overdue unless you are comparing with some other investigation. And so what I'm saying is that if you think, or if anyone suggests that the fact that those investigations have not yielded, have not already resulted in conviction or trial, then it means that we are being unfair. In other words, we are giving some preferential treatment. The point I'm trying to make is that investigations take time. And I'm referring to the Wontumi investigation itself, which has resulted in conviction yesterday, that it started in 2021. And the trial itself started this year, January 13th. That was when we called the first witness. So there is no basis for saying that an investigation that was commissioned somewhere middle of or latter part of last year is not, it has delayed when just because somebody was convicted yesterday. So the point I'm trying to make again is that sometimes we know narratives are powerful, but all you need to do is to run the narrative against facts, and you will see that the narrative becomes empty.
Justice Sremsai, thank you very much for your time this evening. He's the Deputy Attorney General Samuel Appiah. He's the lead counsel for Chairman Wontumi. Mr. Appiah, in 30 seconds, I want to pick your reaction to all that the Deputy Attorney General has said. 30 seconds.
It is very sad for him to say that I fostered the date of the judgment. It was fostered on me. I never chose the date. That's the second point. You see, Justice Sremsai wouldn't want to address the fact that the judge cited a constitutional case the Akusa case, and said where rival meanings have genuinely been placed on those words by the litigants. What is the rival meaning here? We stated our position under the Constitution, and they said this is a different meaning. The judge had no option but to refer the matter to
that is
the Supreme Court.
That is not a correct proposition of the law.
Oh, please. No, but I'm reading page 30.
It is only genuine rival meanings. I mean, if you say
who determines the genuine rival meanings? Attorney General.
When everybody knows that
who determines
the
genuine
fact that you
rival
said it's
meanings?
blue should not engage the Supreme Court's attention for interpretation. That's the point I'm making.
No, but it's very convenient. It's very convenient for you that a High Court should graduate into a Supreme Court and determine genuine constitutional meanings.
The High Court simply held that there is no genuine or real question for interpretation to be referred to the Supreme Court, which is the test. That is the test. So I would pray that my senior would take time to read the judgment, assimilate it.
I've read the judgment. The judgment is before me.
It appears there's a lot of rush to prematurely.
Mr. Attorney General, if you can kindly let Samuel Appiah speak. He was the one on the floor.
Well, with the greatest of respect, the Attorney General concedes that they went into conclave with PW1 and PW2 in a so-called plea bargain. And one of the reasons for the plea bargain that they will come and testify. That is a very serious, issue that we should all look at. So if a man entered into an agreement with the prosecutor, his captor, and that agreement is that come and testify, can he come and testify against the prosecution? Those are
matters for credibility of witnesses, which goes into assessment of evidence.
That's what I'm saying.
There's no bar. I think the proper position of the law is that a person could testify for the prosecution upon plea bargaining, and it is not illegal. But when a person is testifying for the prosecution, a former accomplice is testifying for the prosecution, it goes to the credibility of his testimony, and that is about evaluation of the testimony. So to suggest that it is wrong to let a co-accomplice testify for the prosecution,
I'm not saying that.
Misstatement of the law, and that should not be what we should be doing, because the law allows a person to enter into plea negotiation and reach a plea bargain. The Constitution include being a witness for the prosecution. And this is something that has been happening in other jurisdictions, and with the coming of the plea bargaining law, it is allowed in Ghana, and that has been used in other cases, including a case which my very good friend here is a counseling. So there's nothing strange about co-accomplices or accused persons converting themselves into prosecution witnesses.
Deputy Attorney General, thank you very much. That is Justice Strimsai, the Deputy Attorney General. Earlier, we heard from Samuel Appiah, who is the lead counsel for Chairman Wontumi. The Nana Equiamwa Boatin from Ablekuma Central says the Deputy AG Strimsai should give us a break. His government is in power, so he feels he knows the law more than anyone else. We, the members of MPP, believe Wontumi's incarceration is purely politically motivated. Sam Bannerman in the USA says it will be difficult to win the war against illegal mining if nobody is prosecuted against the act, which is still ongoing. Remember, you can continue to send your messages to the number 055 1111 997 when Edem Kojo comes here for your say. He will share the rest of your thoughts with the rest of the world. It's now time for business. George is here with the latest.
Hi, Kenneth. Coming up, Ghana's total debt stock increases marginally to hit 720 billion Ghana cedis ending June this year. And businesses describe first half of this year as good and encouraging based on improved macroeconomic indicators. The business news on Newsnight is brought to you by MTN Business. Welcome to the new world of business. Kingdom Books and Stationery, your number one-stop shop for all your office essentials.
Your home could be anything you want it to be. It could be a stadium.
He's just 12 yards out. He shoots.
Oh,
yes!
What a strike!
It's a goal.
Or a gaming arena.
Yes! Let's go!
Sometimes a classroom.
Madam, please, I don't understand.
All right, let's go over it again. Which part don't you understand?
The whole shop.
Or it could be an office.
How many orders are ready? Okay, send them to East Legon first.
Or even a research center.
Daddy, what is the Big Bang Theory?
Wait, let me ask ChatGPT.
You can make your home anything you want it to be, because no matter the experience you want at home, MTN Fiber will power it. Get unlimited internet up to 500 megabytes per second from as low as 299 Ghana cedis. Connect your home or business today. Visit the My MTN app or dial *5057# to check fiber availability and request now. MTN.
We dey blast them. Who dey blast? We dey blast them. Who dey blast? We dey blast them. Brush your teeth. Brush your teeth every day and night. After eating before bed, brush the germs away. The sugar germs, we go brush them. Fufu germs, we go brush them. Rice germs, we go brush them. We go.
When it comes to your teeth, Funnel World Cup. Brush them twice daily with Pepsodent, now in limited edition packs. This advert is FDA approved.
Cast your mind back to 2022. The prices were rising. The stress was high. Every liter of fuel felt like a sacrifice. Do you remember who stepped forward first? When others were comfortable with high prices, Star Oil chose you. We cut our own profits so you could keep your AC on, keep your engines running, and keep your life moving without the heavy burden. We gave you room to breathe when things felt tight. Because of you, our star savers, we became #1. Today, the pumps are a battleground. Others are finally cutting prices because they have to. But Star Oil, we do it because we want to. Don't just chase a price, remember a friendship. We were there for you then, and with new innovations coming your way, we are here for you now. Star Oil, still quality and affordable fuels for all.
Introducing Ghana's leading pay-as-you-copy photocopier leasing company. Lease an A4, A3, heavy-duty or production machine and pay for only the copies made, or design your own payment plan. Simple and tietia. That's not all. Incredibly, toners, repairs, maintenance, follow-me printing, centralized tracking all come free of charge. Remember, financial prudence is the name of the game. Folks, forget about the expensive gimmicks and be smart. Join the hundreds of satisfied clients across all the 16 regions and every sector of the economy and save over 60% of your printing costs. Visit us at www.valexlease.com or call 0244-644048. Be prudent and lease a copier. Terms and conditions apply. Valex Lease is a wholly owned Ghanaian company. Valex Lease, affordable document management solutions.
You know that feeling. A hospital bill that arrives out of nowhere. A diagnosis you weren't prepared for. A system that seemed designed to confuse you, and costs that keep climbing. And the stress of not knowing if you are protected. Eden isn't lost. Eden Care was created to give it back to you. Eden Care is health insurance made for everyday family life. With Eden Care, getting healthcare is easy, and you are backed by a trusted insurance partner with years of experience. No confusing terms, just complete protection for your entire family. Step back into peace. Step into experience you can rely on. Reach out right now at 059-692-1844 and choose Eden Care today. Eden Care is brought to you by Acacia Health Insurance, a member of the Enterprise Group.
Eno, you know what our father left us when he died?
Debts?
He left us land, Eno. But Nanayo said the land is his. The court said, come back in 2031.
Hey, that's not an inheritance. That's a curse, brother.
Real Ejapadia doesn't come with disputes. At Deftraco Woodlands, a 592-acre master plan gated city in Dawenya, your inheritance is waiting. Don't leave your children a court case. Leave them Deftraco Woodlands, the Ejapadia they'll be proud of. Visit woodlands.devtracogroup.com. Call or WhatsApp us today on 0208-732-302.
Kofi, I think we need to call them.
Deftraco Woodlands, where your roots run deep.
Sabo. Sasso, sasso, kumen tonton preko. Sasso, sasso, kumen tonton preko. Edrana drumming ya buseshe. Ya hakasia ne malaria. Minya me phone me sasso spray. Every mosquito started run away. Kumen tonton preko. Sasso, sasso, kumen tonton preko. Kumen tonton preko. Sasso, kum tonton preko. Nani shamne die demonstronko.
This advert is FDA approved.
Let's now settle for the details. The country's total debt stock increased to hit 720 billion Ghana cedis ending May this year. Now, this represents a marginal spike compared to the about 695 billion Ghana cedis reported in March this year. The 720 billion Ghana cedis represents about 45.1% share of the total value of Ghana's economy during that time. Now, more than half the debts were funds borrowed locally, while the rest can be classified as external debts. Now, this was captured in the latest economic and financial data of the Bank of Ghana. Meanwhile, the value of the economy in monetary terms is worth 1.5 trillion Ghana cedis. And still in the data, the country's international reserves might have also decreased significantly to reach $12.9 billion ending June this year, compared to the about $14 billion that is in March this year. In related development, the Ghana cedi is now depreciated by some 9.5% against the US dollar. However, when you compare that to the same period for last year, it was still better, as last year we've seen some significant depreciation of the value of the Ghana cedi to the dollar. Now, to other story, the Bank of Ghana has revealed that it will soon move to take action on all unregistered digital credit providers. Now, this was after the expiration of the June 30 deadline that was announced earlier this year by the central bank. According to the Bank of Ghana, it advises the public to exercise caution in dealing with these digital credit providers and ensure that they engage only in entities that are duly licensed by the Bank of Ghana. So other story, businesses have described the first half of this year as good and encouraging. Now, this is based on some improved economic situation which helped them plan as well as expand into other areas of the economy. Joe Jackson is Chief Executive of Delex Finance.
The one thing that businesses hate is volatility. The one thing that businesses hate is the lack of stability. The first 6 months of the year have been relatively stable, have been relatively without the volatility that we had seen in years past. So on that score alone, we would say that it has been a better year. Last year, things were coming down. This year, they've stayed level. Our economy can be described as robust, but not yet fully as resilient, but not fully robust. I say resilient because some of the international challenges, like the closure of the Hormuz Strait, have not affected us as badly as could have happened. But yet, we are not out of the woods yet.
And that is Joe Jackson. He's the Chief Executive of Delex Finance. Now, the Bank of Ghana has assured businesses not to panic due to the current pressure on the Ghana cedi. We have more in the following Business Desk report.
The Bank of Ghana's assurance is based on the fact that it remains in a strong position to meet market demand given the country's current level of international reserves. The Bank of Ghana says this places it in a strong position to intervene in the foreign exchange market whenever the need arises. Sources close to the central bank have also maintained its intervention in the forex market, and the supply of foreign exchange will be guided by policy and market data rather than sentiment. They have also described the current pressure and short-term fluctuations in the local currency performance as expected. However, the bank argues that the bigger concern would be if the pressure is sustained over a prolonged period and whether it would still be in a position to provide the market with the required foreign exchange support. The central bank has also indicated that it expects donor inflows by the end of this month, which should further strengthen Ghana's international reserves and enhance the Bank of Ghana's capacity to support the foreign exchange market.
That is the Business Desk report, and that's all for business on Newsnight. Back to you, Kenneth and Gemma.
Thank you very much, George.
Now, the Office of the Special Prosecutor is tonight firmly rejecting suggestions that a United States immigration court has undermined its criminal case against former Finance Minister Kenneth Ofori-Atta. The response follows a ruling by U.S. Immigration Judge David Gade, who questioned the credibility of the case while approving Mr. Ofori-Atta's application for permanent residency, a finding that he had not been credibly shown to have engaged in criminal wrongdoing. While the decision is likely to intensify scrutiny of Ghana's efforts to extradite the former finance minister, the OSP insists the immigration proceedings are separate from the extradition process and maintains that only Ghanaian courts can determine the criminal charges pending against him. It says it will continue pursuing the case. Let's find out what the U.S. judge said. Ken, so the immigration judge appeared to have questioned the credibility of the case against Ken Ofori-Atta. How is the OSP responding to that?
Right, so the OSP's statement reads, and I quote verbatim, it says the OSP reiterates that the extradition packet is not before the immigration court. The credibility or otherwise of the criminal charges against Mr. Ofori-Atta is a matter for determination by the courts here in Ghana, which have jurisdiction to determine his guilt or innocence. Such matters, the OSP continue to say, are not determined by an immigration court in the United States.
As the public should distinguish between the different legal proceedings. What exactly does it mean and what happens next?
Well, again, the OSP states that it is important to distinguish between three separate legal proceedings involving Ken Ofori-Atta: the U.S. immigration proceedings, which concerns Ofori-Atta's immigration status in the U.S., extradition proceedings in the U.S., which would determine whether Ofori-Atta should be surrendered to Ghana under the relevant extradition treaty, and the criminal prosecution of Ken Ofori-Atta in Ghana for corruption and related offences before the High Court in Accra. It continues to reiterate that Ofori-Atta remains the subject of criminal proceedings in Ghana. A valid warrant of arrest, they say, has been issued by the High Court in Accra, and Ofori-Atta remains a fugitive from justice in the country. It continues again to say that Ofori-Atta is required to submit himself to the jurisdiction of the High Court in Accra to answer the criminal charges pending against him. It goes on to say that the criminal proceedings in Ghana shall continue in accordance with applicable law and the directives of the High Court in Accra, whether or not Mr. Ofori-Atta is present in Ghana. So those are excerpts of that particular press statement released by the OSP.
Ken, let's speak to immigration lawyer based in the U.S., Jonelle Oklu. On this, Jonelle, welcome to News 9. How significant is this ruling to the battles being fought by the former finance minister in the U.S.? At least we know this was one of the two cases he was fighting.
Thank you very much for having me on your program this evening. To answer your question, the immigration judge's decision to grant adjustment of status, this is basically a permanent stay in the U.S. to Mr. Ofori-Atta, does not have a bearing on any criminal charges that are ongoing in Ghana. Also, it does not have a bearing on the ongoing request for extradition to Ghana. To be clear, these are two completely separate legal matters: the immigration matter and then also the extradition hearing. Now, as far as the government of Ghana is concerned, there are two ways in which to get Mr. Ofori-Atta to come back to Ghana. 3 ways, actually. One is he'll just come on his own. He'll just decide to come to Ghana on his own. But it seems that is not going to happen. So the other route, the second route, would have been for them to have him deported, forcefully removed from the U.S. and sent back to Ghana. This decision by the immigration judge basically means that, no, Mr. Oforiatta is not going to be deported back to Ghana.
General Oklu is an immigration lawyer based in the U.S. Thank you very much for your time.
The National Service Personnel Association, NASPA, has suspended its capacity building program after facing backlash from some National Service personnel over the deduction of 60 cedis from their monthly allowances. The association says the suspension is to allow for a comprehensive review of the program's structure and implementation following concerns raised by personnel. According to the president of the association, Abdul Wahab Bala Muhammad, the decision follows a directive from the Minister for Youth Empowerment and Development, George Opareado, that there should be no further deductions on behalf of or in relation to the capacity building training.
As concerns about the program intensified, particularly regarding the deductions and the level of consultation, we took our time to engage our newly elected regional executives, receive feedback from service personnel, and as well as carefully review the issues that had been raised. Over the past few days, we have been engaged by the management of the National Service Authority over the concerns and frustrations expressed. In response to the feedback from the service personnel and general public, and as well as in line with the sector ministers and board's directive, the management have issued this directive to NASPA. The capacity building program, as currently structured, is hereby suspended with immediate effect, pending a comprehensive review of the program for a decisive action to be taken, which is in line with our sector minister, the Minister of Youth, Empowerment and Development.
That there is the NASPA president. Let's go on to Zoom right now and speak to the Deputy Director of the National Service Authority, Major Moses Bengbu. Major, welcome to the program. Now, the bone of contention is the funds that have already been deducted from the allowances of the National Service personnel. Will it be refunded to them?
Good evening and thank you for the opportunity. I'm a Lieutenant Colonel. I was promoted last year, so kindly update your records. Okay. Can you hear me, please?
I can hear you, sir. Please go on.
Yes. So, just like the NASPA president mentioned, this issue has brought a lot of agitation among service personnel. For that matter, management, like he mentioned, we have written to them, or instructed them to suspend the program until further notice.
When is until further notice, sir?
Just like he mentioned, he told you that because it is not sitting well with the personnel, we think that more consultation should be done. And if they deem it prudent for a continuation of the program, fine. If not so, then the program or the capacity building exercise would indefinitely be suspended.
Lieutenant Colonel, was the National Service Authority aware of this deduction? Was it done in collaboration with the NSA?
We will have to be mindful of the fact that NASPA is an autonomous body, which the Acts at 1119 of 2024.
Lieutenant Kenneth, that is well noted, but my question to you is, were you aware of these deductions? Was it done in collaboration with the NSA? Because the personnel are saying that these deductions were done from source. And really, does the NASPA have the capacity to deduct these funds from source?
The deduction was made for NASPA. It wasn't in collaboration with National Service Authority. We were informed of the decisions that they made during their executive meetings. We, as the authority or management or leadership of National Service Authority, do not sit in their meetings. However, when decisions are taken at their meetings, we are duly informed and we guide them. And that is what happened.
Right. Lieutenant Kenneth Moses Bengbu, thank you very much for your time this evening. He's the Deputy Director of the National Service Authority. Let's do sports. What do you have for us?
On Premier League side, Ipswich Town, they have announced the signing of Ghanaian winger Abdul Fattah Issahaku from Leicester City. The 22-year-old joins Ipswich Town for an undisclosed fee and has signed a 5-year contract which will run through to 2031. The attacker featured in all of Ghana's 4 games at the World Cup, including against England in the group stages, and has won a total of 32 caps for Ghana, scoring 3 goals. Now, during his career, he's played in the Champions League during his time with Portuguese side Sporting Lisbon, and has been promoted and featured in the Premier League with Leicester City before scoring 9 goals and 7 assists in 44 appearances for Leicester City last season. That's all for sports. Back to you guys.
Oh, thank you very much for bringing us sports, Daniel. Well, let's now bring you your say. I'm looking for your sick team. Unfortunately, we cannot find it. But, Adam, what do you have for us this evening?
Okay, yeah. So a lot of people have been speaking on today's issues. This one from Wisdom in Agbozome says President Mahama and the NDC should be ashamed of themselves if after campaigning we got to stop Galamsey, you later come to tell us that their own people are into Galamsey. Issa Tamino in Boko says, it is funny the MPP minority in parliament are wearing black because of Wontumi. Fuad from media says, I believe the conviction of Chairman Wontumi is a step in the right direction and great signal for environmental justice. Jonas Frank says, for us, the discerning citizens, all we want to see is practitioners of this heinous act are heavily dealt with. And Kwesi from Ebuaka says, is the MPP saying that Chairman Wontumi, who has been incarcerated, is political? If it was an ordinary citizen, would they say it is political? So these are your comments in there. But beyond the comments, I have a special story for you. So
tell me, what is it?
Let's listen to this.
What is the sound?
Is that not the sound of a mosquito?
Well, yes. So that's the sound of a mosquito. And so today we are entering. We are not talking about the one that bites you for malaria. We are talking about the political mosquito in Ghana. Yeah. So for long we all knew him to be General Mosquito. Do you know the history of why he's even called General Mosquito?
Tell me.
Okay. So I'm going to tell you that story. Now he's called General Mosquito because that's the name the MPP gave him.
Oh.
So apparently, somewhere 2005, he was actually in Parliament. He was an MP for Winchi Central, and he had tried to fight against someone from becoming a minister.
Okay.
The guy was nominated, but Asedun Ketia fought him so much and was successful. So the NPP said, well, you are not majority leader, you are not minority leader, but you were so insistent and made sure that this person was disqualified, and you are acting like a mosquito.
Yeah?
Wow.
Yes.
What a history.
Yes.
I've never heard.
Yes.
And then where did you hear this one from?
That is why I have Adam. Yeah, but that is not even the most interesting part. Well, I think Ketia comes out to say that even General Mosquito is not the nickname that he's known as.
Okay.
Yes. That's when you go to his old school days, he's actually called Archimedes.
Wow. You don't say.
Very wrong.
Oh, he looks like, the name fits him, Archimedes.
Yes.
He looks like a very brilliant chap when he was a student.
Well, he says, they bring him difficult questions and all that. And
wow.
Yes, and after that, he put it on social media and asked people to mention the names, their nicknames. What was your nickname in school? Kenneth?
I don't remember.
Okay, well, I looked through the comments, and this is my Gemma. What's your nickname?
Gem.
Well, I looked through the comments, and this is my favorite nickname. The guy says it's called Big Bentwa because he had a big dose.
Wow. Interesting. That is Adam Kojo with your say, and that's it for News 9 this evening. Thank you very much for being a part of the show this evening. My name is Kenneth. Gyasi?
Well, my name is Gemma. Appiah.
Don't forget to brush your teeth day and night with Pepsodent. Have a good evening.